All right, it looks like we have everybody joined and connected. So we will get going. I would ask everyone if you could turn off your videos, because we're going to be recording the CLE, and it'll make for a better recording for members who couldn't join us this afternoon. Judge Fairgrieve is going to begin with an update from Superior Court, followed by Judge Osler with an update from District Court. If you have any questions, please put them in the chat box and we will get to them at the end of both presentations. So thank you, Judge Fairgrieve and Judge Osler, for giving us these court updates. We find them very invaluable, especially right now when all of us are working remotely. It's very helpful. So thank you both for being here. And we will start with Judge Fairgrieve. And Judge Fairgrieve does have a PowerPoint presentation, and I am going to be sharing that in just one moment. Of course, easier said than done. Let me try that again. All right, thank you, Judge Fairgrieve.
All right. Well, good morning, everyone. Thank you for having me or hosting me here this morning. What I'd like to do, Christy, if you could go to the second frame. So this morning, what I'd like to do is review, some things I've talked about before, or at least the same sort of structure. I want to give you an idea of what's going on with the court right now, and then a little bit about courthouse operations, what we're up to here. Talk about jury trial status, which is certainly a big issue on everybody's minds. Talk about court operations, both criminal and civil, more criminal than civil for a number of reasons. I want to go back to a couple of remote hearing issues that we're still having. And I want to talk about mock trial, which is going to happen next week. So next frame, please. All right, so some big changes for us in our legal community. Judge Banfield and Sheldrick and Commissioner Sasser have all recently completed the state judicial college, which is a good thing. And so they're all in their positions and working at this point. Many of you know Judge Banfield is going to be handling family law cases, and she'll be doing that through our normal rotation. And then Judge Sheldrick has taken Judge Veljacek's caseload on. In fact, she's doing that right now. I talked to her yesterday afternoon for a while about some things she's working on. And then Commissioner Sasser has assumed one of the two non-dependency commissioner positions. Commissioner Ellis has a dependency position, and then the other two positions are there. All right, so as far as courthouse operations are concerned, as I think I mentioned in the past, we've been making sort of incremental improvements in terms of what we're doing, mostly along the lines of safety in the face of the COVID pandemic. There's only one entry point now in the courthouse. Those of you who've been down here recently recognize it's the west entrance by the jail. They're doing temperature scanning, and they're actually asking about symptoms as individuals come into the courthouse, making sure they wear masks. We're enforcing masks and social distancing. One thing I will say is apparently there's been some feedback in Superior Court bench bar about some concerns some attorneys have about individuals getting into the courthouse with their masks on and then not not wearing their masks or not wearing them properly once they get in the courthouse. So we talked about that yesterday at the judges meeting. We're going to try to be more I don't want to say aggressive, but that basically is what we're going to be looking at. Please identify if there are individuals who are in the courthouse who pulled their masks down or not wearing their masks. If you could please, let somebody from court administration know or some of the security personnel know. We'll have security. You'll remind them that they need to wear their masks properly, and if they fail to do so, they'll have to leave the courthouse. There's also hand sanitizer available. And we've completed, being Superior Court, have completed our plexiglass installation in all the courtrooms. So now there's a little bit of added protection there, just by virtue of the plexiglass. Next slide. So jury trial status. Many of you are aware that the Supreme Court allowed us to go back to jury trials as of July 6th. So we were doing that for a while from July 6th until the latter portion of November. And then, basically the Supreme Court gave local courts, superior courts and district courts the ability to make their own decisions based on their own local sort of situation about whether it was safe for them to continue conducting jury trials. Next slide. So starting in November, the Superior Court has met on a number of occasions to discuss what the current situation is. In November, many people are aware we had the first major surge begin, and then our numbers have stayed high since that time. In fact, we've been in a high category in our county until just recently. So we've met 3 times as judges. We decided each time that we could not safely conduct jury trials, and we decided that we weren't going to, that we would establish a moratorium. So the current moratorium goes through March 1st. Next slide. We're going to meet again on February 22nd, next Monday, to determine whether we can safely recommence jury trials. As many of you are aware, the good news both nationally and locally is our numbers have been going down significantly recently. So, that's certainly a big factor we'll look at. But, we're going to have to kind of sound out where things are at this point. Next slide. The 2 major factors we look at, or what we have been looking at each time, is the prevalence of COVID-19 virus in the community, and then what's going on over in our jail in terms of how many active cases we have in the jail. I know the jail was down, I think, late last week to as low as 1 case among 1 prisoner, and I think they had 3 staff members out with COVID symptoms or isolating at that point. One thing I did want to say to all of you is, if you have input you'd like us to consider before next Monday when we meet again at noon, please feel free to forward that information. You can forward your input in terms of whether we ought to restart jury trials or whether you feel it's safe to restart jury trials. You can send that information to me, or you can send it to our administrator, Ms. Gurley. I will certainly pass it on to the judges when we meet next Monday at noon. Next slide. All right, so current criminal operations, we've been pretty much up and running in terms of our normal docket structure, certainly for the last few months. We're running all the same basic dockets that we had been running before the pandemic began. We have a little lower volume on some of the dockets, like change of plea dockets, just because it takes us longer to do certain things. But we have our full sort of range of criminal dockets at this point. One thing I would say about that is that we have certainly shifted to a structure where we're trying to do some matters off docket as far as, for instance, agreed continuances. Those are kind of routinely being handled by the attorneys. They'll prepare and sign off on a agreed scheduling order, basically continuing the case, and we're able to handle many of those off docket. The net effect of that has been to shrink down our Thursday readiness dockets significantly. And so I'd like to thank all the attorneys who are working on that and have been doing that. Let's see, actually, we need to go back one. Okay. I wanted to talk about a couple issues within the criminal world that we've been working on. One problem we've had on and off since the pandemic began is the issue of criminal paperwork flow in and out of the jail. This is principally statement defendant on plea of guilty, but it also could be speedy trial waivers as well, or frankly, anything that needs to get into the jail, be reviewed and signed by a defendant, and then back out to defense counsel. This has been a problem. We created a structure early in the pandemic that allowed us to get the paperwork in and out, and seemed to be working kind of relatively effectively for a while. For a number of reasons, the jail made a decision they weren't going to use that process any longer, and ultimately that's their decision. We had long discussions with them and couldn't prevail upon them to continue using the process that we created. We had been working for a significant period of time on trying to solve this issue. We finally did allow, or Indigent Defense hired a new employee who started on Monday, or rather on Tuesday. She's being trained up. My understanding from talking to Mr. Kimball is that this employee will probably actually start working to facilitate the paperwork flow in and out of the jail as early as this upcoming Friday. So, we'll know as time progresses here, probably in the next few weeks, how effective that is for us. It's our hope that this is going to take care of, or at least, certainly decrease the problems we've been having with the flow of paperwork in and out of the jail. The whole focus of this employee is to help criminal defense attorneys get documents into the jail, facilitate getting them to criminal defendants there, and getting their signatures on these documents when they've been counseled on the documents, and then getting them back out to the criminal defense attorneys in a timely fashion so that we can try to speed that process of resolving these cases. Next one. Another issue that has been a regular issue concerning the jail is the ability of criminal defense attorneys to have contact with their clients who are in the jail. What occurred, not surprisingly, is that once the COVID pandemic began, a number of criminal defense attorneys were not comfortable or felt it was not safe to go in and visit their clients in the jail for any number of reasons. We recognize this. Certainly this has been an issue. It's been with us since the beginning of the pandemic. We've been looking for solutions. The solution that we've been able to identify is reconfiguring some of the meeting rooms that are there in the jail to make them, set them up so that we can allow defense counsel to have Zoom meetings with their clients in those rooms. Basically, there'd be a video hardware, in the actual room there, and we'd be able to set up pre-set up appointments with criminal defense counsel to be able to talk with their clients about their cases or paperwork or whatever it happens to be. At this point, we're still waiting for some input, I think, from county IT, who apparently has to do the wiring for these rooms because they're going to need to be wired for this equipment. Additionally, there's purchase of the hardware that needs to occur and the software as well. I don't have a solid time for completion on this. In fact, I just talked briefly with Mr. Kimball this morning on some other issues, and I don't really have a horizon here. We know this needs to get done. He knows it needs to get done. He's been talking with the county manager about this issue. So hopefully we can, make this more of a priority and try to get this process established, because we do certainly need to give criminal defense attorneys more ability to contact their clients in the jail. Next slide. A couple comments about remote hearings decorum. The good news, and I would say to everybody, is that by and large, we're conducting a vast majority of our hearings now using remote means through the Zoom platform. The vast majority of those hearings are effective. They come off without a hitch, and a lot of that reflects, I think, the hard work of all the attorneys who are out there to come up to speed and to learn how to use Zoom and make sure that they and their clients can use it. A couple things I'd like to just mention. One, please, as far as attorneys are concerned, please dress as if you're going to court. That hasn't been a problem for most of our local attorneys. I've had some attorneys from other jurisdictions who come in occasionally, and they're not wearing clothing we'd normally wear into court in terms of jackets and ties and that sort of thing, but just be aware of that. If you're coming from your home, please make sure that you set up a quiet place to be able to do the hearing. That hasn't generally been a problem, but a couple of times it was. You might want to consider using a background. Certainly, if you're at home and you're on, Zoom from your home, of course, that's a little window into your home. There may be things that you don't want other people really to see. And of course, the whole backdrop, if you're in front of, like, for instance, a bookshelf that's got a bunch of personal mementos or things like that, but up there, maybe you don't want that information displayed to anybody who might click into the Zoom hearing. So you might want to just consider that. Please test your audio. This is a continuing problem for us. Probably every hearing, there are a couple, maybe attorneys or certainly, other parties who are in the hearing whose audio just doesn't work very well, and that creates a big problem for us. So if you participate in a hearing and we're having problems hearing you, you might want to take a look at that. There are a number of relatively inexpensive ways to improve the audio capability of your computer, like a little microphone or that sort of thing, and that may really help out. If you have problems with background noise, you might want to consider a headphone with a microphone. That seems to be pretty effective for some attorneys. Next one. Please talk to your clients before hearings and inform them that they need to dress appropriately. I think I may have mentioned the last time I was here, although it might have happened since then. I had a party in a bathrobe sitting on the side of his bed in one of my hearings relatively recently. So let's please not do that. Please have them mute their phone and turn off their camera. And for a couple of reasons, it's better just from the amount of data that's coming in, but also candidly, sometimes parties are doing things when they have their camera on. And candidly, it's pretty distracting to watch somebody get ready to go and then drive their car down to a local marina and get on a boat while they're waiting for their hearing. So if you could just have them do that, that's probably makes it a little easier on the judicial officer who's hearing the hearing. They need to be in a quiet location without distractions. It's very distracting if they're trying to deal with a court hearing and taking care of kids and dogs and whatever else is going on in their life. Please remind them they're in a court hearing and they're on video and that everybody's watching them. It seems like some people forget they're on Zoom and they do some rather remarkable things while they're in the hearing, like driving, which for a while was a very common event. I used to watch people drive all over town waiting for their hearings. As far as future operations are concerned, I think I mentioned in the past, but I'll mention now, I think we're probably past our crisis phase in terms of planning. We've created a series of structures and processes that are allowing us to do what we need to do. So we're getting now toward more of a sustained planning model. We're operating under the assumption that social distancing is probably going to be here with us for another 6 months or a year. We've got an increase in criminal case volume at this point. I haven't really seen a good breakout locally, but I do know that nationally, violent crime and homicides in particular are up significantly. I just don't know if that's the case here. And we are still, even though we are getting more effective at running hearings, it still is taking us longer by and large to run hearings remotely. Next slide. There's in addition to the Superior Court Bench Bar, committee, which meets once a month and deals with a broad range of issues, we have another committee, the Criminal Policy and Procedure Committee, that meets, has been meeting recently every other week. Sometimes it meets every week. But we use that committee to discuss issues that are facing the criminal side of the house and to try to identify solutions that we can use to address problems we're running into. It's a great forum for addressing a lot of these issues. You can certainly participate in a meeting if you'd like to. Just let me know and I can send you an invitation. There are points of contact, like Sean Downs is the criminal defense representative who's usually there. There's a prosecutor representative, somebody from the clerk, the jail, and other representatives. So certainly that's one of the tools we use. And if you've got a concern or a problem that you're facing in terms of criminal process procedure, that's a good place to go. If it's more of a civil thing, then probably the Superior Court Bench Bar Committee is a great avenue to get those issues aired. Next slide. Civil dockets and probate and guardianship dockets have been reconstituted and they're going well. I would say that a lot of the probate and guardianship matters are being dealt with off docket at this point in terms of non-controversial or sort of agreed matters. And that's proving to be effective. It's shrinking down the size of the dockets and overall seems to be a more efficient way of doing things. Next slide. We are planning for the resumption of the unlawful detainer docket. The current moratorium is set to end on March 31st. Hard to tell at this point if there's going to be an extension. Judge Gregerson, who is our point of contact on that, was mentioning at our judges meeting yesterday that I think his belief is that we're probably not going to get an additional extension, but we just don't know. I guess as we get closer to March 31st, we'll know that. But we're mindful that there is a huge, pent up wave of UD actions that are out there, and we've got a plan for them to come forward. Family law dockets and trials from Judge Vanderwood and Collier and Judge Lewis, those seem to be going well. They seem to be effectively using remote means and in-person appearances, and they seem to be able to do their cases pretty well. Next one. Next last matter is the high school mock trial is going to take place next week here in our jurisdiction. We're about one of four sites in the state that are going to be running the regionals or divisions before the state one. So that's next Tuesday, Wednesday, and Thursday. The rounds begin at 2 o'clock in the afternoon and 5:30. I still need judges for, I think, 5 of the 6 rounds. So if you're interested in being a judge, please, send me an email if you like. And I still have a series of slots. At this point, we're accepting, attorneys into those judges slots. Additionally, if you'd like to be a rater, Commissioner Sasser is running the recruitment for all the raters. We still need raters for all the rounds as well. And if you could contact her and let her know that you're interested, we'll certainly get you signed up. It's all going to be remote this year. So basically you'll get an invitation to a Zoom meeting. And so you'll just log on. So you can log on from your house or your office or wherever you are, and in either rate or judge a particular round. So we've got about 12 teams from all over Western Washington, and it should be a good experience this year. All right, I'm going to take questions when Judge Osler's done. So thank you very much for your time.
Thank you, Judge Fairgrave. And now we have our district court update from Judge Osler.
Thank you. And I always give Judge Fairgrave a hard time when he does those PowerPoints because I don't think I'm as technologically savvy, but I do appreciate them having said that because they're helpful. So I'm going to follow off of some of the points that he made. Obviously the court operations extend to both district court and superior court. And I think we would be happy to look out for people that also aren't masking or social distancing. So if you just alert our clerk's office, we can try to address that as well. And just one other point, if you weren't aware, is there's also a worker that works in all 3 of the courts that comes around and sanitizes the common areas, the doorknobs and things like that as well in the courthouse, and that's done daily. Jury trial status, we try to be consistent with Superior Court in the sense that we can be. So we'll probably meet next Tuesday after their Monday meeting. I'm just making a plug since I do have Judge Fairgrieve on this meeting, is that I'm kind of hoping now that I'm in the DV unit that we'll be able to resolve jury trials effective March 1st, because I do think those numbers have gone down fairly significantly. I think we're back to numbers like we were back in July of last year, where Superior Court deemed it appropriate if we took necessary precautions that we could go ahead and resume jury trials. But we'll make a decision probably shortly after Superior Court's decision on the resumption of those jury trials. So you should know more about that by next week, early next week. Also, if you have any input you want to provide, you could provide that to Amber, Emery, Judge Parcher, or myself, if you have a strong opinion or just an opinion on the resumption of jury trials at this point. My main thing to talk to you about today, well, and one little caveat, I just wanted to join in. I always want to join in with Judge Fairgrieve when he brings up the remote hearings decorum, because although you guys have all probably seen the cat video with the lawyer, I haven't experienced that yet, but I did have someone shoveling snow yesterday. So if they can kind of make their cameras go down while they're not in the hearing and not drive, that's always a big one. And then kind of my pet peeve is I'm hoping that the attorneys are getting more and more where they're not on video, and we want it to be as much like court as possible. So we like the attorneys, and to the extent possible, defendants to be on the video, because we're recording that video. It's a court recording. We do have, just so you know, we've called them pro se booths. Courtroom or G2. If you do have a client that just doesn't have the capability of remoting in, we do accept people in court, but sometimes when the attorney's remote and the client is in court, it's difficult for you to communicate with them. So we do have some booths available, and they can at the district court clerk's office, if they come in and they want to be able to remote in, we have some computers down there where we get them set up, and then they can remote into the hearing. So our main thing that we wanted to talk about today is our court operations in light of Galenas and the criminal rule 3.4 changes. It does affect our dockets. Traditionally, criminal wise, what you'll get now is you'll do an arraignment will be your first court appearance, which is under the rules is mandated that a defendant appear at. And then from arraignment, you're given a mandatory court date. And then we have review dockets, and oftentimes we see a number of cases get set over and over and over and over on these review dockets prior to being set for trial. So a review of the state court rules, 4.5 criminal rule of limited jurisdiction indicates or allows us to have a pretrial hearing. So at arraignment, moving forward, starting March 1st, you will get what we've always given you as a mandatory pretrial hearing. So that will stay the same. We're no longer going to do the pro se pretrial hearings where they meet with the prosecutor. We haven't been doing that since the COVID anyhow, but we will work with the prosecutor's office to figure out a way to best facilitate them being able to get a hold of a defendant that's not represented by counsel prior to their next court date. So those mandatory court dates will still be set out about the same time frame that they're set out now, 45 days if you're out of custody or 30 days if you're in custody. What will be different though is that mandatory, if your case does not resolve on that court date, your case will be set for readiness and trial. So criminal rule 3.3 D1 actually mandates the court to set trial within 15 days of arraignment or at the time of the pretrial hearing. And so we are going to be setting more cases for readiness and for trial off of those mandatory court dates. We will have, and there's some discussions with the judges, but we will have change of plea dockets or criminal review dockets still available. So the idea would be then you would just cite a defendant on once you reach resolution to one of those dockets for resolution. And that might be entry of deferred findings, diversion, change of pleas, whatever the case may be. And then we haven't enacted a local court rule like Superior Courts yet, but we are in the process of doing that. I did do another COVID order when we extended the latest jury trial. And on that, the court is making a good cause finding that the mandatory pretrial hearings and the readiness hearings are, there's good cause to require the defendant's appearance unless allowed by the individual judge to be waived. So there may be some exceptions to that rule, but it's the only way with the volume of cases we have in district court that we can move our cases towards resolution. I currently in district court on any given trial date are setting them 15 deep on a trial day. So I need to have the ability to move those cases. So readiness is for the most part, unless the judge allows for a waiver of the defendant's presence, will be a necessary court appearance. The DWS docket is going to get phased out. So our last docket on that will be on March 25th. Any cases that may be set after March 25th, we will absorb on one of the other dockets. And the reason for that, one is because we're going to be setting cases for trial. And two, both the prosecutor's offices are handling the way they file DWSs differently now. And so our DWS numbers have gone down significantly. So we don't anticipate having that many driving while suspended cases going forward. And let me see. Order is on the website if you want to look at that. Oh, one other thing is we had signed an order up until the end of January where people that were given report dates to jail to serve their sentence, the jail was allowed to set those out for 45 days. Now we're back to normal. I mean, there are still some limits on what's going into the jail from district court, But we have a lot of DUI cases. We're processing a lot of folks that have a 1 or 2 day jail sentence that they need to serve. And so the jail should be accepting those folks now. And I think, let's see, if we covered anything else. Civil dockets, those are running similar to what we had before. So we still have your ex parte docket. There'll still be a weekly civil docket that the judges will handle. We tried to get the judges, going back to criminal here for a minute, we tried to get the judges to be consistent. And I know because I covered a non-DV judge today that our calendars have not been updated yet for those changes that are going to go into effect March 1st. So hopefully by March 1st, please make sure you check the judge's court calendar so you know exactly when things are being scheduled. But just to give you an overview, on an individual judge's arraignment week, that will remain the same. They'll still do arraignment and bar every day. On their trial weeks, they'll still do trials Monday and Tuesdays. These are non-DV judges. And then they will have available those change of plea / criminal review dockets for you to cite cases on as needed on Wednesdays and Thursdays of those 2 weeks. On the second trial week, you may or may not know we have a bench warrant quash docket that we've been doing on our civil week every Thursday. We do up to 12 bench warrant quashes every day on our arraignment week, but oftentimes we have more than that. So the overflow bench warrant quash dockets will be handled at 10 o'clock on Wednesday and Thursday of that second trial week. Mandatory week, mandatory for state will still be on Tuesdays. Mandatory for city will still be on Wednesdays. I don't know if there was total agreement amongst the judges, but you may start seeing that they're going to start staggering some of these dockets and have an 8:30 time slot for Vancouver defenders and 10 o'clock time slot for private retained attorneys and pro se. So you just don't have everybody sitting there at 8:30 waiting for their case to be heard. So that should help alleviate some of the congestion on those dockets. The judges will, on their mandatory week, will still go out to Camas on Thursday and we'll still do a PV docket like we've always done on Friday. The main thing that will change is our civil week, where on Thursday and Friday, there'll be readiness hearings now conducted. So your readiness hearings going forward won't necessarily just be 1 week in advance, but they'll be 2 or 3 weeks in advance. And we've been meeting with stakeholders and getting their input on these docket changes. I know that one of the private retained attorneys brought up to me that oftentimes by the time of mandatory, you haven't even had your DOL hearing, for example, on a DUI case. And so, you know, it's difficult to know really the status of that case. And so the judges are more than amenable to setting cases out farther if you need some additional time so you can accomplish some of that stuff. And we're hoping that the prosecutors and defense attorneys will work together, meaning prosecutors won't cut off pretrial offers on any mandatory dates, but maybe extend that out a little bit further if the trials are set out farther. Camas won't be changing much as far as the format, other than trials out in Camas will also be set at mandatory, but the judges will be out there once every 5 weeks. They're able to handle their readiness hearings on that docket, which will be about 2 weeks before your trial date. So Camas shouldn't look too differently than what it looks like now. And I think that is all I have on. So if there's any questions, we're free to take those.
Thank you, Judge Osler. If anyone has any questions, feel free to put them in the chat now. I would just note that the PowerPoint presentation that was prepared by Judge Fairgrieve, as long as a link to this CLE will be sent out tomorrow. So check your emails for that if you want to have that or share that. Also, if you haven't already, please click on the link in the chat box so you can register to receive a CLE credit for today's presentation. And speaking of CLE credits, we have a CLE coming up on March 10th. It's going to be on personal injury. So if you're interested in that, do sign up for that. And if you haven't already, sign up for our mock trial next week, as we need raters and judges to help make this tournament a success. So do we have any questions? And doesn't look like there's anything in the chat. So if someone wants to unmute themselves or turn their video on and ask a question, they absolutely can do that as well. We'll wait just another second. This is your chime to ask Judge Osler or Judge Fairgrieve. They're your captive audience and are happy to answer any questions. So if no one has anything, we will conclude our CLE for today. We thank everyone for participating, especially Judge Osler and Judge Fairgrieve for taking the time to update membership on what's going on.
Thank you.
Thank you.
Thanks very much.